Have you ever wanted to own rental properties? Do you want to avoid liability as a landlord? Do you want to understand the key issues in the Delaware Landlord Tenant Code? If so, you're in the right place. Stay tuned for the answers to these questions and many more. Hi, I'm William Dolan, and this is Esquire Advice, where we explain complicated and lucrative real estate and business topics. Remember, we are not forming a lawyer-client relationship by way of this channel. Always consult your local attorney before taking any action. With that said, grab a pencil and a piece of paper and get ready to learn. Welcome to our episode on buying and holding investment real estate, part 2. First, we're going to discuss owning investment real estate in a legal entity to protect your personal assets and the assets of your other companies. Then we are going to cover many of the key concepts in the Delaware Landlord Tenant Code. Now, the Landlord Tenant Code from each state varies, but there are also many similarities. So you can use this video as a guide, but before you present a lease agreement to a tenant, you need to have that agreement reviewed by an attorney licensed in the state in which the property is located. Okay, so you always want to own each piece of investment real estate in a separate LLC, and here is why. Anytime a party gets sued and loses the lawsuit, the plaintiff gets a judgment against that party. We're going to call this party the judgment debtor. Again, that is the person who lost the lawsuit for our purposes. The landlord, right? I mean, that's who we're talking about. That's who we're worried about losing a lawsuit. Once a plaintiff has that judgment, it can collect against the assets of the judgment debtor, again, our landlord. We're talking about cars, bank accounts, stock accounts, real estate, and the like. What's more, Delaware, along with essentially every state, has a judgment lien statute where the judgment becomes an automatic lien against all real estate owned by that judgment debtor in the state, with some very limited exceptions. The plaintiff can also register that judgment in other states. Therefore, the judgment debtor cannot refinance or sell any properties subject to the judgment lien without paying off that judgment. It also means that the plaintiff can foreclose on all of the properties subject to the judgment lien. So, if the judgment debtor, whether a person or an LLC, owns multiple pieces of real estate, the plaintiff has a judgment lien against every piece of real estate. However, if each piece of real estate is owned by a separate LLC, the plaintiff will only have a judgment lien against that one piece of real estate, and the plaintiff will only be able to execute on the assets of that one LLC. The assets of the other LLCs and your personal assets are no longer in play. One final note on LLCs. If you have a partner, you should consider a holding company structure. That would save you a lot of money on income tax preparation costs and give you a few other benefits too. Check out our video on holding companies for more information on that topic. Now we're going to shift gears to the Landlord Tenant Code. The first key concept is applicability of law. Let's contrast this with the LLC law. For example, if you have a Delaware LLC, you can use that Delaware LLC in any state in the US. In fact, people use Delaware LLCs all around the world. And as it relates to the internal matters of the LLC, like limitation of liability, Delaware law is always applicable. So generally, the protections you get from a Delaware LLC do not change based on the state in which you are using it. However, with the Landlord Tenant Code or Landlord Tenant Matters, the state in which the property is located will always control. That means you cannot say, I like the Landlord Tenant Code in South Carolina, so I'm going to use those terms in my lease agreement for my property in Delaware. No, you have to follow the Delaware Landlord Tenant Code for your properties in Delaware, which means you need to know what the Delaware Landlord Tenant Code says. The second key concept is fair housing rules. A landlord cannot refuse or decline to rent, subrent, sublease, assign, or cancel any existing rental agreement or charge more rent for or to any tenant or any person by reason of their race, creed, religion, marital status, color, sex, sexual orientation, gender identity, national origin, disability, age, source of income, or occupation, or because the tenant has a child or children in the family. Whew, that was a mouthful, right? That really should be pretty straightforward. So what we're talking about is you have to evaluate prospective tenants on the merits and not based on stereotypes. This should be self-evident, but to be sure, let's review some examples. You can make decisions based on credit and income, but not because you think a particular group of people are dirty, poor, violent, or weird. The third key concept is the summary of the Landlord Tenant Code. The Delaware Landlord Tenant Code requires a landlord to provide each tenant with a copy of the summary of the Landlord Tenant Code as prepared by the Consumer Protection Unit of the Attorney General's Office. You are going to want to get each tenant to sign a document confirming that it received a copy of this summary, because if you fail to provide the summary, the tenant will have the right to plead ignorance of law as a defense. This would be a disaster for the landlord, since the tenant would not be held to any of his or her obligations under the Landlord Tenant Code if he or she simply said, "I didn't know that." In case the inference is not clear, generally no party can claim ignorance of the law. In other words, usually all parties are charged with knowledge of the law, which puts the burden on the parties to do their own due diligence and know what they are allowed to do and what they are supposed to do. The fourth key concept is a lease agreement, or rental agreement as it is called in the Delaware Landlord Tenant Code. There are three very important items here. First, any term in a rental agreement where a tenant is waiving or foregoing rights or remedies under the Delaware Landlord Tenant Act is prohibited. Second, the rental agreement cannot provide for a confession of judgment. And third, it cannot have the tenant exculpating or limiting landlord's liability or indemnifying the landlord either. If a landlord tries to enforce one of these prohibited provisions, the tenant is entitled to damages in an amount of 3 months' rent. Okay, let's unpack what all of this means. The first restriction that states the rental agreement cannot have terms where the tenant is waiving or foregoing any of its rights or remedies under the Delaware Landlord Tenant Code requires the landlord to know the code inside and out and ensure the lease or lease agreement is 100% in compliance with the code. The code is long and has lots of provisions. We could not possibly cover all of the provisions of the code in this video. Therefore, you must have a Delaware attorney that practices landlord-tenant law advise you on this. My recommendation is to purchase a form lease from such attorney, as that will be the most cost-efficient way to protect yourself. However, you still need to make sure that you know all of the rules so you're not violating them. If you're going to use a property manager, you will want to make sure the property manager is indemnifying you for all of its violations of breaches of not only your agreement, but the Landlord Tenant Code. The second requirement to not include confession of judgment terms is easier to deal with. Just don't include a provision to confess judgment against the tenant for violations of the lease or rental agreement. The third restriction is important too. I've seen many leases and spoken to many landlords who say, "I'm not too worried. My leases have the tenant waiving its rights to go after me and or indemnifying me for any of my losses." But you cannot have these kinds of provisions in your lease agreement. And if you try to enforce them, you will be liable to the tenant for thousands of dollars for just trying to enforce them. The fifth key concept is essential services. The landlord must provide hot water, heat, water generally, and electricity. And if any of those fail at any point, the landlord has an obligation to remedy the situation within 48 hours. Failure to do so will allow the tenant to either terminate the lease agreement or reduce the rent that it pays each month by 2/3, at least for the days that the failure was ongoing. The sixth key concept is the 5-day letter. Yes, the dreaded 5-day letter. If the tenant defaults on its obligations to pay rent, the landlord must provide at least 5 days written notice before the landlord can terminate the lease and try to evict the tenant. If the tenant pays the rent and the landlord accepts the payment and does not reserve its rights, the landlord can no longer evict the tenant. The seventh key concept is that the landlord cannot engage in self-help. This is an important one. That means the landlord cannot simply lock the tenant out. The landlord needs to take the tenant to court, win the case, and have the sheriff remove the tenant. A violation of this rule can result in not only civil but also criminal liability to the landlord, so it's very important. All right, so the eighth key concept is security deposits. A landlord cannot take a security deposit that is greater than an amount equal to 1 month's rent. If the tenant will have a pet that is not certified and trained as a support animal for a disabled person, the landlord may also charge a pet deposit, provided the amount of the pet deposit does not exceed an amount equal to, again, 1 month's rent. The landlord is required to keep tenant deposits in a separate escrow account with a federally insured bank that has branches in the state of Delaware. The landlord must also inform the tenant where the security deposits will be located. The easiest way to do this is to provide the name and the address of the local bank branch in the lease or rental agreement. If the landlord fails to deposit the security deposit in the way we just discussed, or if the landlord fails to provide the information to the tenant within 20 days of a written request from the tenant for the location of the bank, the security deposit is deemed forfeit by the landlord and it must be returned to the tenant. If the landlord does not return the security deposit to the tenant within 20 days of the forfeiture, the landlord is liable to the tenant not only for the security deposit, but also damages in an amount equal to 2 months' rent. So just provide the information in the lease and take the risk of this issue off the table. After the end of the lease, the landlord must provide an itemized list of damages to the premises and estimated cost of repair for each item, and needs to pay the tenant the difference between the amount of the security deposit and the amount of the total of those repairs or damages. Damages from pets should be deducted from the pet deposit first, and to the extent they exceed the pet deposit, the security deposit. The tenant is entitled to double the wrongfully withheld amount if the landlord breaches this provision. This also means if the landlord does not meet the 20-day time period, the amounts will be considered wrongfully withheld. So you have to stay on top of this. I hope you've enjoyed this episode of Esquire Advice. Please kindly hit those like and subscribe buttons so we can keep bringing you valuable and profitable content. With that said, thanks for watching, and I'll see you next time.